Okay, I now call this, that's a little close, I now call this meeting of the ZBA to order, 7 o'clock sharp. Kim, can I get a roll call, please?
Commissioner Board Member.
Sorry, what?
Sorry, that helps. Member Barconi.
Here.
Am I pronouncing that correctly?
Yes, ma'am.
Thank you. Member Roscoe.
Present.
Member Troutman.
Here.
Member Williams.
Here.
Member Wilson.
Here.
Anybody else? I think that's it.
Don't think so. We have a quorum.
Thank you.
Moving on to item 2, approval of the agenda.
Place forth a motion to approve the agenda as written, in its written form. Support.
We have a motion and support. May I get a roll call, please?
I hope I'm right. It was Member Roscoe,
Yes.
Member Williams,
Yes.
Member Barconi,
Yes.
Member Troutman,
Yes.
Member Wilson.
Yes. Motion carries. Next item, first hearing of the public. Is there anyone that wishes to speak? And not today. Moving on to approval of the minutes of the last meeting as published.
No. Mr. Chair, if I may, I don't think we have anything. It's been several years, sir.
It's been a while. Okay, I think we can omit item 4. Moving on to the preface, do we still have to read that out loud?
Yes, matter of course, in case there's anybody watching at home.
Very well, sir, I will do it. The City of East Point Zoning Board of Appeals primarily addresses practical difficulties based on lot size, location, shape or contour, and/or locations of existing buildings. Article 17 of the East Point zoning ordinance guides our decisions. There are 7 members on the ZBA plus 2 alternates. 4 members constitutes a quorum. A majority vote of those present and voting is required for a motion of appeal or denial. Each appeal before the ZBA will first have a public hearing, at which time the appellant will first present their case, and then any public comment regarding that issue will follow. During this time, members of the board may ask questions of clarification. If a particular point gets belated, the chair has the right to limit comments. When public hearing is closed, the board will move on to deliberation phase. If the appellant should disagree with the board's decision, they have the right to appeal to the Macomb County Circuit Court within a time frame established by statute or ordinance. When the agenda items concludes, the applicant is welcome to leave or stay for the remainder of the meeting. Moving on to new business, we have election of officers. It is normal operations that we have a full board of 7 members before we conduct a election. I make a motion that we table new business item A until such time as these chairs are filled.
So I'll second. Troutman.
We have a motion and a second. May I please get
Support.
There we go. May I please get a vote?
Chair Wilson,
Yes.
Member Troutman,
Yes.
Member Barconi,
Yes.
Member Roscoe,
Yes.
Member Williams.
Yes.
And the motion carries. That is tabled till a further time. Item B, adoption of the 2025 meeting schedule, which is in our packet. Are there any questions or comments on the appeal schedule?
None here.
I'm not there yet, but here we go.
Mr. Chair,
Yes.
if I may put a suggestion on the table for our minutes, our schedule. we'd like to make sure that this board going forward meets at least 3/4 times a year, mandatory. And if that would be the case, I'd like us to be able to consider the first month of the quarter being a mandatory meeting that we know, even if we don't have an agenda on the table, it'll give us training time, discussion time, planning time, particularly in this next 12 to 18 months as we get into a new 5-year master plan. And there'll be conversation that we'll be able to have in that. So if that would be the case, today is the May, which would be in the April, May, and June quarter. We already have that one. So we get to July, that should be a mandate one. Our October should be a mandate one. Excuse me, our October should be a mandate one. And then January would be our next. So every 3 months, we should have one. If we do it the first month of each quarter, then we'll get inside our mandate, even if we don't have anything. And if for any reason the building department drives the city crazy and we get a lot of zoning board of review appeals, then we can eliminate any of the mandatory document dates. That would be my recommendation.
Okay, it is within the chair's recommendation to call for meetings, so. Counselor, are we within our rights in the code to do that?
Yes.
Would you recommend a vote on the item?
Yes, I would.
Very well. I make a motion that going forward, the Zoning Board of Appeals has at least one meeting per quarter.
Support.
And Mr.
Support.
Chair, do we want to just specify for purposes of the motion what those dates include?
You
Once
can.
again, yes, I would recommend that, Chair.
Okay.
Brother Chairman, can I get those months again? I know it's January and July, or January, April.
April.
October.
January, July,
Yeah, that's what,
October,
yeah,
and January.
that's what I thought, yeah. Thank you.
Okay, so January, April.
Okay.
Okay, moving forward, that we have a regular meeting in July, April, March, and October.
No, it should be
January,
January,
July,
April,
April and July.
July, and October.
That's
Yeah,
correct.
Yep, that's
yes.
what I have.
Moving forward, we'll have meetings on those days regardless if there is an item for appeal or not.
I so move.
And, okay, we've got a motion and support. May I get a vote, please?
Chair Wilson,
Yes.
Member Troutman,
Yes.
Member Barconi,
Yes.
Member Roscoe,
Yes.
Member Williams.
Yes.
Motion carries. By all means.
So are we not meeting next month? Or is that just not mandatory?
It's not mandatory. What it is the ZBA historically has only met when there was an item up for appeal. We have a new building official that will probably have us meeting more often, but would like to get together 4 times a year just to discuss what's going on, even if there isn't anything.
I got you. Okay.
Because we haven't had a meeting
3 years,
3 years, something like that?
almost.
It's been a minute.
Yeah.
Since they changed the fencing ordinance, for some odd reason, it's been quiet.
And Chair, we do have a candidate that's on the docks for the next one if he gets in time to get the public hearing in. There is a marijuana sign ordinance request for an appeal, and there is another one appealing a fence issue. So if they get their dockets in time, then it may be next month, but if nothing else, it certainly will be the following month that we'll have several cases on the dock.
Okay.
Okay, very well. Okay, and then I guess we would need a motion to adopt the 2025 meeting schedule as amended.
Mr. President, I so move.
I support.
Or Mr. Chair, excuse me.
I'm sorry, Mr. Chair, I didn't catch who made the motion? Was that Mr.
The
Williams?
motion to accept the
Correct.
meeting schedule as amended with with additional meetings.
Mr. Chair, I believe we already voted and that passed.
We voted and it passed.
Yeah, the next
I
item,
think it was just for the.
It was just for the 4 meetings.
Four, right.
We never
now
approved
we-
the schedule as written.
Right.
oh, I
Right.
thought it was the schedule as written with the amended.
I don't think I
Changes.
worded it such.
He did not.
Just covering, making sure that we've got the additional meetings covered and the schedule as submitted.
Okay.
Call.
So I'm going to go with Member Troutman,
Yes.
Chair Wilson,
Yes.
Member Barconi,
Yes.
Member Roscoe,
Yes.
Member Williams.
Yes.
Thank you.
Motion carries, so schedule is all set up. Moving on, item C, review of ZBA roles and responsibilities. I believe this is a presentation.
It is. We don't have use of the screen, so if you could just, you can follow along in the smaller versions in your packets. Would it be helpful if I stood up there? Are you okay with that?
Whatever you're comfortable with.
Yeah, but we can hear you.
I'll go over there then. John wants me to go over there.
And I would encourage members, new members of the board, if you have any questions, please raise your hand and ask.
Good evening.
Good evening.
So since my understanding is we have a mix of seasoned veterans and newcomers to this board, since we don't yet have any business, we thought it'd be a good idea to just sort of set the tone and get you all started again and review some very basics about what you do as a zoning board of appeals and the sorts of cases that you will hear and some guidelines for doing the business that you will be doing. I will go through this really quick. There's a lot of slides in there, but I can talk fast. Please, at any time, if you would like to talk about something or if you have a question, just stop me. So I'm on slide 3. There's a couple state laws, state of Michigan laws, that enable the work of planning and zoning in a municipality. The one that we're focusing on, or that is most relevant to you as the Zoning Board of Appeals, is the Zoning Enabling Act, which allows municipalities to zone the land in their community. It allows municipalities with some restrictions to control where uses are located, how dense the community is, what development looks like, things like that. And so that is the guidance that we use to draft the zoning ordinance, that we use to amend it. There's always case law and litigation that affects how land use law is practiced, so we make every effort to make sure that you are, that the guidance that the staff is providing you is considering all of that. Slide 5 is just to make the point that there is a large team that administers and works to make sure that the right kind of development happens in the city. There's 3 of us here, and there's many other people, both here and then your fellow boards and commissions. You in these chairs, you see one particular part of this process when people believe or allege that they're being treated unfairly, or for some reason the ordinance is not granting them rights that other people have. But there's a large team that keeps everything moving, and this board is an important part of it. The other thing to point out about this team is that the staff are here to advise and to give you the best information possible, but you have to decide. You don't have to accept recommendations if you're not convinced by them. We try to make them as sound and as correct as possible based on what we understand about the situation in the law, but ultimately the decision is yours. So the Planning Commission sets the master plan. They do the work of guiding amendments and writing for the zoning ordinance itself. They do development reviews, and they are, in that sense, on the front line of processing development. City Council has some role in approving some uses and some things that have some discretion, some possible discretion. Some things the ordinance says, if physically they're what the city wants, then it has to be approved. There are other things, there are other uses in certain places that are not necessarily permitted by right. They could be appropriate for a place if certain conditions are met. And for all those uses and all those things where the ordinance allows, the legislative body has some discretion. You, as the Zoning Board of Appeals, come in when either someone reads the zoning ordinance and thinks that there's an inappropriate regulation that's going to prevent them from developing the way they do, or they apply to do something and someone on staff says, the zoning ordinance says you cannot do that, so I deny your permit application. This board has the function of making sure that the administration is not being arbitrary or being incorrect in interpreting the zoning ordinance, and also to the other responsibilities to hear in a public forum discussions about when the zoning ordinance makes blanket statements all over the place. It treats many, many parcels in the same way, but as you know, because of the way streets are laid out, because of the way topography and natural resources go, parcels and pieces of land and different land that might be zoned similarly is not situated similarly. And sometimes property owners do get treated unfairly by a regulation that is across the board or across very many parcels. The zoning ordinance, the fundamental purpose of that is to protect public health, safety, and welfare. It's the means by which the city ensures orderly development and growth. And it provides for a way to enforce the rules, essentially, to make sure that land use is moving in the direction of what is defined in the master plan and what the community aspires to. Section 2 of this presentation about Zoning Board of Appeals, I just wanted to review really quick. There's 3 types of things that the zoning board by the ordinance has the responsibility to do, or has the authority to consider. Primarily what you'll get, most of what you'll get is variance requests. And a variance is a permanent and officially approved deviation from the zoning ordinance. It means that someone wants to do something that is not allowed in the black and white text of the zoning ordinance. That, if they are granted that right on that piece of property, they will be able to ignore that particular rule. In East Point, the only variances that can be granted are called dimensional variances or non-use variances, which allows an area or a setback or a height or some other area or bulk characteristic of a development that would not otherwise be allowed or doesn't comply with the ordinance regulations. The other type of variance is called the use variance. That is when, in some communities, if a piece of land is zoned for residential only and someone, because the market is, because the market is not functioning, or because they think that they can make a project work on a piece of land that does not allow that use, they can apply for what's called a use variance, and that essentially changes the zoning map at the zoning board. For that reason, it's not a common practice, because it's taking the power of deciding what the zoning map is and what the zoning ordinance is out of the legislative body and puts it at this table. In East Point, the ordinance says that you cannot grant use variances. So the variances that you'll get are from the physical characteristics of the requirements in the zoning ordinance, and someone is asking to not have to abide by that rule. In order to grant them permission to do that, they should present to you evidence that they have a practical difficulty with complying with that ordinance. Practical difficulty is a jargon, but it's the standard that you have to clear before you get, that should be proven in order to get a variance no matter what. The East Point zoning ordinance also includes a set of 5 or 6 specific standards that are listed on page 12, or I'm sorry, page 10. And as the East Point ordinance is written, the applicant should prove to you that each one of these check marks are evident. And we can, as we go, we can go through these, and if you have any questions about what these words mean, just really quickly, if a variance is warranted, something should be unique. Some conditions or circumstances should be unique to this property compared to the other properties in the zoning district that can comply with it for reasons other than what apply to this one. Yes, sir. It stays with the land. It partially depends on how you word the motion. Sometimes the variances are granted based on the very particular set of drawings that is presented to you. But without that wording, and Mr. Albright can correct me or add details if there's some that's there, it will run with the land as it changes property owners, et cetera. So if a setback is reduced from 10 feet to 5 feet and the next owner buys the property, or 2 buildings later someone does it, unless it's specified to occur for one specific development, that setback is always 5 feet. The second standard is that the special conditions are not self-created. There's often a lot of confusion about the term self-created, but self-created means that the current property owner or any previous property owner has not taken an affirmative step or designed something that is causing the problem that they're seeking relief from. So if a house is built to the maximum that is allowed by ordinance, and then someone is asking for a variance to reduce the setback because the house is already built out and they can't build anywhere else, that is an example of a self-created difficulty because there was an affirmative design decision taken, and the condition that is being caused isn't because something is unique about the land, it's just that the property was developed in that way. So there's often a lot of confusion about that, and at least in this instance, or when this comes up, I will do my best to sort of put in the reports and the reviews just reminders of that. The third one is that literal interpretation of the ordinance or strict compliance would deprive the applicant of rights enjoyed by other property owners in the same district, or would render conformity with those restrictions unnecessarily burdensome. And there's some aspect of someone is being treated unfairly and all the other parcels, because they're orthogonal and rectangular, can have this particular setback, but because the last one is triangular, there's no way to make that work, then a variance might be warranted. The next one is the variance will not confer special privilege that's denied to other lands, so that's trying to avoid setting a precedent that you grant this special permission to one person, and then all the people that complied or all the people that have not yet tried to make it work. If they don't have that permission, then there's some unfairness that's built into that. The variance requested is the minimum necessary for reasonable use. So a good thing to think about in the back of your mind is there an alternative to this? Is there a way that, if the applicant has proven that they're being treated unfairly, is there another solution or an alternative that changes or impairs the ordinance less than what the applicant is asking? And sometimes there's not, and sometimes there is. But if there is, then it's appropriate to seek that as to not approve the larger variance, and we would also counsel the applicant to seek a lesser one. And then the last one is that the variance will not be injurious to the neighborhood, public safety, or otherwise detrimental to the public interest, just not causing a problem by granting this permission, even if all these other things are met. So the majority of the business that you will get will be these variances. There are times when someone is trying to develop a piece of property and the language in the ordinance is not clear, or the administration isn't administering and interpreting the ordinance in a way that someone disagrees with. And those people or the staff could bring to you a request to interpret the language in the ordinance. In these cases, they're more rare, I would say, but in these cases, it's important to remember that when you're interpreting the text, you should interpret it narrowly, interpret only the clause or the item that is in question. The decision that you make should be considering the history of the language use and how it has been interpreted in the past. The ordinance provides rules about how to interpret maps or questions about the map. It's not so much an issue. I don't think there will be many issues about that in East Point as it's already built out. But if there's a question about whether a line falls on one side of the road or another, or if it splits a parcel in half, there are times, if there's a dispute about that, that you might be asked to consider and make a decision about, does the line follow the river or not? Bad example here, but, and the last point in there is just, we will all keep records to make sure that, as you set that precedent, it carries over further. And then the last thing that you are authorized to do by the zoning ordinance that you might be asked to do is to appeal an administrative decision. So someone comes and applies for a sign permit, or there's a recent case where a property owner was cited for having storage improperly in the backyard of their property. And if it happens that the staff either misinterprets the ordinance and makes a mistake, or if they are just not enforcing it fairly, I don't think that would ever happen, but hopefully it won't ever happen. But if something just arbitrarily, if someone is being treated differently than every other person in the city, that applicant could come to you and say, I think there's been a mistake made, or I think I am being mistreated, and ask you to overturn that decision. It's different from a variance. It's just a decision about whether or not a mistake was made, or if the staff is truly mistreating this person in a way that they don't treat other people. So in the East Point zoning ordinance, the actual language there's a language that guides that decision, and it says that the decision should be appealed if the ZBA finds that the decision or the requirement or the determination was arbitrary or capricious, based on an erroneous finding of material fact, it constituted an abuse of discretion, or it is based on an erroneous interpretation of the zoning ordinance. So again, like mistakes or really egregious differences in standards. That second one, really both of them, hopefully you'll never get an appeal like that, but certainly, hopefully never the arbitrary and capricious part. I had put in the printed slides that for each decision, after the applicant presents their case to you, you deliberate, you ask questions of the applicant and the staff. If you decide that the applicant has or has not met the standards that they're required to meet, you'll vote to approve it. I had put in your printed slides that votes are based on the entirety of the board, meaning 7 members, which would mean that you would need a majority of 7 instead of a majority of the members that are here. In preparing for this, I reread the ordinance. That's a situation I'm more used to, but in East Point, it's actually the majority of the members that are here and voting are authorized to make a decision, which is it will help do business faster in communities where the entire board is required, or a majority of the entire board is required. Those communities are often forced to offer the applicants another meeting and postpone the matter until they can seat a full board. So in this situation, that avoids that. So just, if you were following along on page 13, I had put in what I thought was always the case, but in East Point, it's not the case. It's, to approve a measure, you only need the majority of the people that are at the meeting. On slide 14, there are some examples of, or there's a little quiz question about which of the following reasons are to approve a variance. I've already been talking a while, so I'll skip to the fact that it's a trick question and that none of those are appropriate reasons. Really, the only thing that you should be considering is whether or not the applicant has proven to you that each standard, that they have a practical difficulty and that each standard in the ordinance is met based on what they put in writing in the application, plus what they tell you at the hearing and, you know, and answer to your questions. All of those things on slide 14 are reasons that sometimes, frankly, variances are granted, but by law and just by basic fairness, it really shouldn't be. I would say that there are many more variances that are applied for than are justified. This system is here for a reason, and it definitely happens that the regulations are too broad, or for some reason there are special cases that warrant relief. But it's also the only way that someone can ask again if they get an answer they don't like. So sometimes you might receive applications that are not necessarily justified, but they have a right to be heard. We try to counsel people honestly about what the standards are and what they have to prove, but in my experience, that doesn't always dissuade anyone because they expect that if they can just get up and talk, they can convince people. So the end of it, I won't dwell on the end of the presentation. There's just some pointers about risk management in conducting this business. You can't really avoid litigation, but if you follow all the procedures that are laid out for you in your bylaws, in the zoning ordinance, you use sound decision-making principles, and you don't participate in decisions in which you have a conflict of interest, then you can really minimize your risk. Those decision principles, I think, are good to reference. The board, you are bound by the standards in the ordinance. Property owners have rights to utilize their property, but those rights are limited by the ordinance. And justification for variances must be related to the conditions of the land. There are cases where the ordinances are unnecessarily burdensome. That is a little bit in the weeds, but I think the first part of that is that it's just a very basic decision or a filter about whether or not you might consider granting a variance. Is this something that is happening because of the way the land is situated or because of something the applicant affirmatively did? The responsibility of the ZBA is to really to uphold the requirements of the zoning ordinance, except in those unusual circumstances. It's not the job of the ZBA to help the applicant find a way around the requirements because they're inconvenient or because there's a compelling reason. There really sometimes might be a compelling reason or a reason that you want to grant a variance, but really in order for the whole thing to work correctly, it should only be granted if those 5 standards are met or those 6 standards. Another common thing that happens is trying to solve the problem for the applicant or suggesting things. Really, you should only be considering what the applicant brings to you and not, it's on the slide, this is designed from the day. It's just, you know, saying, well, maybe you wouldn't need a variance if you turned it this way and brought it back 10 feet. Because again, the burden is on the applicant to prove to you that he or she is being treated unfairly. Some do's and don'ts on page 20. Some of this is just Robert's Rules of Order, but conduct deliberations in the open, work through the chairperson. When you express your opinions, it's a good idea to sort of state your reasoning. That's helpful in setting precedent and in making the decisions defensible if people want to challenge them later. If there's mistakes, we'll just work to correct them immediately. You should not confer with your fellow members outside of the meeting about the decision of the case. You are under no obligation to act hastily or take action if you have any doubts. You can always ask the staff for more information. You can ask the applicant for more information and save the decision for another time. Yes.
Yeah, if you should feel the need to see the property yourself before the meeting and you want to go look at it and have a see at what's going on, do not engage the owner in any conversation, debate, or about it at all. You cannot talk to other board members before the meeting. You cannot talk to the owner. That opens us up for liability and failure.
That's a great point. Anything that has to do with your decision-making should be discussed in this room only or just in your own private prep. Thank you for
Yeah,
that.
Mr. Chair, yeah, because this is a board subject to the Open Meetings Act, that's why you want to avoid any type of conversations amongst members too. I would ask this, on our application for an appeal variance, is there something on there, is there a waiver and consent that allows or gives consent of the board members to enter upon the property? By signing that, you give consent to the board members to do that?
It wasn't originally when I got here, but now that I'm here, we've got Jackie and Roseanne rewriting that and putting that waiver in.
Okay, good.
Because we feel that that would be viable going forward, that you have eyes on it and have the right to be there.
Yeah, okay, thank you.
Okay, thanks. There are a few slides just of some Cliff's Notes or maybe things to reference about do's and don'ts during meetings and about making decisions. We've covered most of them already. Really the important ones are don't discuss with anyone before the meeting is in session. You'll be provided, hopefully, all the facts, provided all of everything from the applicant, and some collection of those facts from the administration. A good thing to do before the meeting is to review all the standards that'll be used for that decision. And then, again, just some do's and don'ts about during meetings and sound decisions. And finally, on slide 25, you will often find yourself in the position of turning down a request. It might help you to think about the hundreds of thousands of property owners that do comply with the rules that someone is asking for lenience from. Zoning ordinances take a lot of time and effort on the entire municipality's, on behalf of the entire municipality to create. So to the extent that we can make them work, as long as they are recent and accurate and really reflecting the wishes of the community, everything works better if it's enforced consistently. If you get into a pattern of making concessions, then you sort of lose the ability to stand up for the ordinance provisions when you want to. So that's just something else to think about. And the master plan, there's another master plan that's just started. When those processes happen, they involve lots and lots of public input and they translate that public input into policy that then theoretically everyone is trying to realize. There's something at the end, quick, about conflicts of interest. If you have a financial interest in the matter, or you have a relative or a close friend that is the applicant, or you are somehow representing the applicant, not so much for an appointee, it's important to identify those for yourself and to make them known as soon as you possibly can, or as soon as you understand that there is that. And then you should really refrain from voting on that matter, just to keep everything above board, and so there's not even the appearance of any impropriety. There's questions on page 28 about what constitutes a conflict of interest. If you're the applicant, yes, there is a conflict of interest and you should not be voting on it. If the applicant is a relative, probably, but maybe not. You know, you kind of have to evaluate each decision for yourself separately. If the applicant is a neighbor, it might be possible for you to be impartial about that, but you really should disclose it to the rest of the board so the entire board knows that you have that relationship with that person. Similarly, if your firm works for the applicant or the applicant is a business associate, then you might well have a conflict of interest. You might well, because you work in a different side of the company, or there's nothing financial to be gained, or there's no relationship to be impacted based on how you decide. Maybe it's possible that you can do that without having a conflict. If there's a business competitor, then that's pretty clear conflict of interest. And if you just don't want to vote contrary to the public comment, if you're not comfortable doing that, then that is also a conflict of interest, and you should probably step back at that point. Thank you very much. I'm happy to answer any other questions, but looking forward to working with you.
Thank you very much for the training, Paul. Moving on to the next item, unfinished business. Being none, we will move on to the second hearing of the public. Does anyone wish to speak? Anyone? Being none, we will move on to the board member comments.
Mr. Chair, if I may, before we start, if we could add admin before we start. No, public comment is done. You already closed that. No, I'm not the public. Mr. Chair, just so particularly people who are new know, the building official and the planner will always be providing recommendations and documentation. You are more than welcome, in advance of the meetings, you are more than welcome to reach out with questions at any time individually. Again, because of OMA, you don't want to, do it as a group, but they will always be providing recommendations. And similarly, like tonight with the chair, the city attorney will always be here for the meetings to let you know he is also going to be available for questions. Again, individually, should you have anything like that. I do want to point out that I want to make sure everybody has a roster of the individual. I make sure everybody has the contact info. This is private to you guys. This is not public. We only put your email addresses on the website. So these are phone numbers and emails just between this group that are just with us and with Roseanne, who's the clerk for this committee, this board. There are training opportunities. I put with each of you, you have the binder of all kinds of things. I think Mr. Myers will talk about that. But there is, Michigan State University has a number of different opportunities for training, planning, zoning, different things. Citizen Planner is a great initial course if no one's taken it. I believe Mr. Wilson, Mr. Roscoe, Mr. Williams have taken that. But there's also new ones for ZBA. There are trainings that are in person. There are trainings that are online at your own, that are online on a schedule with other virtual, and then there are also trainings that you can take on your own time. The city will cover your training. Obviously, preferences are given to those who have not had training yet. But we also do get scholarships or group discounts. So for those of you who are new in particular, these courses are really interesting to learn. So the General Citizen Planner is a great one because it covers both. But this packet I gave you has also the Zoning Board of Appeals. So please reach out to Mr. Myers or myself or Roseanne if you're interested, and we will sign you up for those trainings. And then I think, if I may, Mr. Chair, Mr. Myers, we have a new company we have a new consultant for a master plan. It's time for the city to do its new master plan update. The state requires a focus on housing, so we're going to focus on that. And then, but we have a grant. We also have a second grant that focuses on economic development and placemaking strategy for the commercial corridors, and we have another grant for that. So we are about to kick that off. So I think Mr. Myers will talk about that because we are looking for some volunteers.
We're not about to kick it off. On May 2nd was the first launching date officially, and we had our first administration meeting today. We will have every 2 weeks administrative meetings with that selective team as we go forward. They already have projected months and dates scheduled for coming into the city and doing public hearings and meetings and reviews of the city coming here in the near future. But in this master plan, I'm trying to not be too excited about it. I'm thrilled, and I hope you get so excited about what you're doing sitting on a ZBA board. If you feel like you're going to get in the next 18 months your plate full of cases to review, it's because of him. No, I'm just kidding. No, I'm just kidding. It's because your staff hasn't folded and just said, okay, you can do it. We've set on the standards. The new zoning board of the zoning ordinance was established November of 23, and our job is to stay on top of it as cleanly as possible with no variables. And if they want the variable and we cannot talk them off the ledge, they're coming to you. So when you all of a sudden see a larger number of cases of variances being asked, it's because you know your staff hasn't moved the needle of what has been written. And we want everybody to be equally treated across all the lines of all of our zoning districts. And to do that, they need to come and speak to people like yourself who live, operate, and function as a ZBA board to hear a bipartisan guideline. So when we talk about if you need to see the property, we've done this in other cities, we'll talk about this in our administrative office, but a board like this that has to go on somebody's property, it may not be too unheard of to actually give you a zoning board of appeals board identification so that you are identified going on, that you belong to the city's responsible parties, and you're not there violating the legal requests that were granted to do. So we'll try to put those in your hands so that you're really comfortable going where you want. Again, it's already been spoken. You can, when you get to this public hearing, that's listening to them and listening to us, this zoning board has to then talk out loud all your opinions about what you heard. And we have fortunate that the city attorney is going to sit here and catch you every time you step across the line and do something illegal that we shouldn't be doing. So that means you should feel really comfortable saying whatever you got to say out loud so everybody hears it as you discuss. Your discussion isn't the vote. Your discussion's just the open discussion. It's not a closed session conversation. It's an open one. But he'll be here to make sure that we don't cross any lines, just like we're going to be on the other side of the administration telling you why we brought this case, because we are not crossing any lines. We're excited about that. But that brings us to this master plan. And we don't see a major overhaul in the mapping of our master plan But we do have a company coming in, and we are looking at the issue of how do we revitalize the city of East Point? And these are topics that haven't been officially put on the docket yet, but the question was, how do we increase the population from what we have consistently for the last 10 years to something higher over the next 5, then the next 10, and to the 2040 era? Number two is, how do we increase the population of families that move in that actually have children that go to our schools and increase that population? Next subject in this master plan is, what strategies can we do that we can reduce the household rental properties and bring it back to homeowner occupied community again? And what's the goals for that? That will be so much of an involvement of what you guys are going to hear, learn, and do as a ZBA, that you'll have a footprint in doing that with us over the next 18 months. That's the excitement of saying, can I see what we should be looking like in 15 years instead of hope it works out and something gets done by accident. We want to plan that, we want to implement that, and then we want to see the resolve of that. So one of the things, if you can get excited about this visionary development for the city of East Point over the next 18 months, if you have an interest to be on any of our structural boards, one being a the steering committee, we can't have 30 or 40, but we have to have a broad approach of multiple types of people. So if you'd like to sit on that steering board, I can't promise you'll get on it, but if you're interested, give it a message to me or to Kim or Roseanne, and we'll put your name on that list and go, let's see if we can get this as a multi-complex group of people that can have a very strong voice. That steering committee will speak very loudly to the company that we brought in, asking them to keep giving us direction of what we're asking for. And so that's the excitement about being on some of these commissions, this committee, or well known as what they call stakeholding organizational pieces. Obviously, the Planning Commission will have a piece in it as they look at some of these things at the details before they get to council. But if you'd love to understand that we're not just talking about how do we remap the city, we're wanting to know, how do we revitalize it? How do we change the economic status of our city's population right now, household, to a higher number? How do we create a healthy place for the large population of retirement to still be here and finish here and then have their homes and houses ready for the next generation? How do we do those kind of things? That's this year's cycle of my master planning. And we've got to hit the marker today, this coming cycle, so that we're planning for 2040, 15 years out. And so I'm excited about being here for the idea of helping bring new, fresh life, not only just to the business districts and what we really work hard with Paul in the economic district neighbors, but what are we going to do with our neighborhood? What are we going to do with each of our neighborhoods? Where's our worn out neighborhoods, and how do we help revitalize it intentionally so we can change some of these dynamics? So I'm excited about the master plan just a little bit. And
Yeah, we can tell.
and I can't imagine why anybody wouldn't love to be able to sit down and be a part of writing a vision statement that says we know where we want to go and where we'd like to be in 15 years, even if none of us may be here at that time. That would be the fun of setting. The only thing I tell my children I can leave is the history of what I've done. I can't leave all the money. I'm not going to be over wealthy. The only thing we can leave to the city is the quality of things we leave behind for them to use. And this is why we do master plans, to bring freshness and hope and vitality to the future generation, not to ours. And so what can we do to leave it there? So if you have an interest to put a little bit of time in over the next year, 18 months on this master planning, we'd love to hear from you so we can already plug you in and get you started. Any questions for me? If you haven't figured it out, I am the new building official. Next week, I will finish my first full year here. And I have given a lot of people, probably my bosses, a headache. But we're excited to be a part of bringing life to the city. And I think you're going to see a little bit more action over the next 18 months because people are used to being told, do whatever you want. And we're going to go, no, we have a design program in our zoning ordinance, and we need to figure out why we should or shouldn't be keeping it. All right? Anything else? Thank you for giving me a minute, sir.
But of course. Okay, back on the track. Are we moving on to board member comments, Kim? Okay. Forgive me, but I'm a little rusty. How do we do that again?
Mr. Chair, I think you can ask each of the members if they have anything to comment. I know it's been a long time. I forgot to.
I couldn't remember if we ask individually or if we just kind of.
There's no particular order. You can change it up every single meeting. If I could just make a comment, though, just in touching on what city administration said, in my 15, and yes, I do attend all of the ZBA meetings, so I will always be in this chair. In my 15 years of attending these meetings, there hasn't been one case appealed in the circuit court that from any decision that this board has made. So previous boards have done a really, really good job of coming up with well-reasoned decisions, and one of the best ways to prevent litigation is having a very, very solid record. So if a member is going to make a decision either to approve or deny, going through the factors that the planner discussed and then giving their reasons for why the maker of the motion believes those factors have either been established or they have not been established. And then if, of course, there's a second for the motion and there's a vote and it passes, it's a very, very good way to prevent an aggrieved party from then taking it a step further and filing an action in the circuit court. And I also wanted to say, I am here at all the meetings, and you can certainly ask me questions prior to the meeting, but you're not limited to that. If you have a question and you want to contact me during the week, in the evening, please don't hesitate to give me a call. That's why we're here. So, thank you, Chair.
Thank you. And thank you very much for being there. I appreciate being able to look over and counsel. Could you clarify that? I appreciate that so very much. Okay, Mr. Fishman.
Thank you for the opportunity. The mayor and the city council, thank them, and I'm looking forward to working with my fellow committee members for the next year, at least a year or so, and I'm looking forward to it. Thank you.
Mr. Roscoe?
I'll piggyback off of my fellow cohort there. It's going to be an opportunity to learn the various things in this venue here, and to just thank for the opportunity and my cohorts working with me, and I'm working with them as a team.
Mr. Edwards? Williams.
First name's Edward, last name's Williams.
Williams, there we go.
That's okay. Thank you, Mr. Chairman. Thank you, board. I'm excited to be a part of the zoning board. I think since I've been on it, this is a second meeting. So, yeah, I'm not new, but I'm kind of new. But yeah, I enjoyed taking the classes with Michigan State, and we learned a lot. And I'm just looking forward to, getting my feet wet and, finally actually doing something. I was like, Robert, does this board really exist? But yeah, thank you.
Thank you. Ms. Barconi?
Hello, everyone. I am excited to be here, excited to learn, and I am interested in those classes, by the way. I'm just happy to be here and just ready to just get started.
There we go. Well, I'd like to thank everybody for being here. I'd like to thank the old members for coming back and the new members for taking the time out of your schedule and giving an hour or two to help the city run smoother. It is appreciated. It sounds like Mr. Myers has some interesting, exciting things coming up for us. So I look forward to seeing what's going to happen, and thank you all for serving the city.
Thank you.
Comments being finished?
Mr. Chairman, I move we adjourn.
Support. Mr. Troutman made a motion, Mr. Roscoe supported. We have a motion on the floor to adjourn the meeting. May I get a vote, please?
Second.
I think we're good. Member Troutman?
Yes.
Member Roscoe?
Yes.
Member Viconi?
Yes.
Member Williams?
Yes.
And Chair Wilson?
Yes. Thank you very much. We'll see you all
8 o'clock.
we may have one in June, but we will have one in July.